Hello, my name is Gayle Calderwood. I'd like to apologize for my voice. I have a bit of a cold. I would like to thank Chairwoman Delosio, Representative Davis for having us here today, and to all the members of the Judiciary Subcommittee for having taken the time to listen to what we have to say and to read the testimony from all the witnesses today. As Mike Burton said, this is an extremely vital, important piece of legislation because it fundamentally alters our custody laws in Pennsylvania, laws that have been in place for some time, but have been altered over time with input from our section, the family law section of the PBA, the Pennsylvania Bar Association. I am the immediate past chair of the family law section. Mike took my crown in July. We serve for a year each. We represent over 1,000 practicing family law attorneys in Pennsylvania, the bulk of whom solely focus on family law. And I will tell you, it's not the most popular thing to practice as a lawyer. It doesn't pay well. It's tough, it's emotional, it takes a toll. But we have a shared goal of the family law section, which is to meet the needs of the parties and the citizens of the state, meet the needs of children in custody and support and related cases, and to reduce litigation. It sounds like an oxymoron, but we have pushed for legislation that literally reduces the work that we would have to do because we know that increased litigation is negative for parents and children and takes an incredibly bad toll upon small children and even teenagers and even adult children in a family. It's very difficult for people to go through these things. And custody in particular is probably the most contentious, most difficult area of practice. To court. Now, looking at this statute, I think everyone in this room has shared goals. We all would like to make things better for the children. But how to achieve those goals, we have differing opinions and differing methods. And I think it's important, as Michael said, that the laws that we have in place now have evolved over literally over 100 years and have shifted away from presumptions. And in part, that is because judges are humans. And when they see a presumption written into the law, they tend to treat it as a rule that cannot be changed. Even if you provide for exceptions to the presumption in the past, they proved very difficult to impossible to overcome. So as lawyers, we, over the decades, became anti-presumption, and the courts share our opinion because the courts saw the cases come through and saw the end results. We are on the front lines of dealing with this issue. We see a multitude of families of different types and people with different issues. And while the people in this room all have shared interests, they have different experiences. And some people in this room may view things a certain way, but as Michael said, there are some assumptions that we have heard mentioned that are not true. One assumption I heard is that the courts think that one parent is automatically better than the other, and that is absolutely not true. People come to court on equal footing. The court focuses on the factors, and each party has a chance to argue their case. And in fact, I've practiced over 20 years, and I've represented a multitude of fathers who have been awarded primary and/or sole custody of their children due to serious issues within the relationship that the children have with the mother. And I also represent grandparents and aunts and uncles and great aunts and great uncles who have taken over the care of children because of serious problems within the family and have primary and/or sole custody. So there is no assumption in our court. The focus is on the best interests of the child. This statute has, unfortunately, some serious problems as we view it from a legal standpoint, but also in the practicalities of how it would affect families. It creates, as Michael mentioned, a very high evidentiary bar. It uses the language clear and convincing evidence. That has real meaning in the courts. It has been defined by case law. Both attorneys and judges understand that to mean the highest bar, the biggest hurdle to overcome when you go to court and have to argue. You have to have evidence that is both clear, direct, weighty. Your testimony from your witnesses has to be clearly understandable and not open to question. But that's not what happens in a custody case. In a custody case, 99% of the time, it's he said, she said, from one parent to the other. You don't often have third-party witnesses in your home day to day watching you while you raise your children, watching you take them to school or get them dressed or do their homework. The only people who can testify to the majority of the evidence is parents. And so again, it becomes a he said, she said situation. The courts rarely have a situation where they're looking at clear and convincing evidence in a custody case. They're looking at those factors, they're looking at the credibility of the witness, and they're making a decision based on all of the evidence without any presumption. And that is a very key thing for the children involved. The children deserve to have their needs considered. And with clear and convincing evidence, the case law has stated that the trier of fact would have to be able to make a decision that is one of clear conviction without hesitation of the truth of the precise facts at issue. Now, that may sound like a bunch of words, but what that means to lawyers and judges is you have to be crystal clear. You have to know exactly what the right result is. That is not what happens in custody cases most of the time. Most of the time, the court is trying to determine what's best for the child. Not what's best for the parents, and there's not crystal clear evidence that it should be shared or it should be primary or should be sole, although maybe in sole custody there tends to be more crystal clear evidence. But what we need to do is to allow the judges to weigh the evidence. Allow the parties to present the evidence and argue the evidence. And if we put a clear and convincing standard in, which in the civil courts is the highest standard, we prevent that from happening. I think that it is important to remember, too, that there are some issues in the language of the statute where it's eliminating terminology and introducing new terminology that will clash with other statutes that we have and other rules, including the support rules that we have in place. It also, I would like to note, and based on my experience again, but also the fact that we've dealt with it in my immediate family, it will not cure parental alienation. Forcing children to spend 50% of the time with two parents, one or both of whom are trying to carry out parental alienation, will not solve the problem. It just puts the children in the middle of the war, literally. And it makes the children think it's their fault, it's difficult for them. What we as practitioners have been told for over a decade now by the experts, who I think you'll hear from, is that intense counseling is what cures parental alienation, both for child and parent. Not forcing time. Now, there are cases of parental alienation where the court would order 50-50 custody despite the parental alienation. In fact, as Michael mentioned, that is the trend in family law. And again, that's another assumption I heard stated today that was incorrect. Most cases resolve out of court. Of the 100 cases we might have a year in our firm, probably 85 to 95% of them will resolve outside of court. Sometimes parties will start the court process, but very quickly reach a settlement, often with some input from the judge or a master who's assigned to help out. But it is still not a litigated result. It doesn't go to a full hearing. Putting language that creates a presumption in the statute, parties will latch on to that. They'll say, well, I could get shared custody 50-50. I want that. They will be less likely to settle for 55% for mom and 45% for dad, or dad getting 60% and mom only getting 40%. They are going to want to fight. And I can tell you as a practitioner, the hardest thing is talking your client down off that ledge when they want to go to war. What we try to do in custody is prevent those wars. We want people to resolve their issues, be creative in how they resolve their issues, and look at all of the factors when they do that. Their job, the distance, do they travel for work? All of these things impact how they can parent and what time they can spend with their child. I would also like to say that from the standpoint of grandparent custody, I have concerns with the statute that it negatively impacts the rights of grandparents that have been created by the statutes that we have in effect currently. And that will be, I think, expanded upon by subsequent testimony, but I do believe that it particularly eliminates the ability to achieve partial custody for grandparents, and it could even negatively impact the parents themselves and the child, because it could grant grandparents 50-50 custody more often than would ever happen under current statutes, and that would be viewed by many parents and even the children as an interference in their normal day-to-day routine. But we can expand upon that with further testimony. Again, I have represented a myriad of cases where mothers do not get shared or primary custody for a variety of reasons. We see cases where parents have mental health issues, drug addiction issues, prison sentences, abuse perpetuated by that party. We see parents who simply cannot be a parent and are gone from the child's life for years at a time. We hear the worst stories and we deal with the worst situations that you could imagine. But yet we are able to resolve most of those cases out of court to the benefit of the child. This statute would make it far more difficult for us to do that. So I would ask you to please consider not passing the statute as written. And thank you again for listening to our testimony. If you have any questions, we are available.